Good evening to all of you. Welcome to Legal Matters by Sai Baba Sunkara. In this video, we are going to discuss an important point on the dying declaration. Whether dying declaration recorded by a police officer is inadmissible because it is recorded by the police officer, because it is not recorded by the magistrate, because it was not recorded in the shape of questions and answers. The answer will be no. The police officer can record the dying declaration. It will be admissible under section 32 of the Indian Evidence Act. Of course, there are certain circumstances which we are going to discuss in this. So this relates to the case law, State of Jharkhand versus Shailendra Kumar Rai, alias Pandav Rai, in Criminal Appeal number 1441 by 2022, decided yesterday, that is on 31/10/2022, by two judges bench, Honorable Justice Dhananjay Chandrachud, DYC, and Ima Kohli. The two judges bench of the Honorable Supreme Court of India held that the dying declaration does not become inadmissible merely because it was recorded by a police personnel. This is important. Basically, you know what is the dying declaration. The concept before the the concept behind the dying declaration is truth lies on the lips of the person who is about to die, or a dying person will not speak lie. So therefore, it is an exception to the concept of hearsay evidence. According to section 32 of the Indian Evidence Act, whoever gives any statement relating to the circumstances leading to the incident or leading to his death, and if he dies, then it can be proved. That is the importance of section 32 of the Indian Evidence Act. So normally the fact should be proved by the person who makes the same, but here the person dies, but still his statement is admissible. This is the value of the dying declaration. Therefore, there is a procedure, and normally whenever the person is likely to croak or die, the concerned medical officer will send an intimation to the jurisdiction doctor through the intimation of accident and injuries. So therefore, the judicial magistrate of the concerned area, he will come and record the statement dying declaration. Before that, he will get himself satisfied that the person is in a fit condition to give a statement. For that, he will record or he will get the attestation from the medical officer also. And first of all, the magistrate will get the satisfaction by saying that he is so and so and whether he can identify him or not. Then he will ask him, he will record the dying declaration. In the meantime, he can put some questions, and it can be in the shape of questions also. This is a routine procedure. But here what happened is, on 7/11/2004, 18 years back, on 7/11/2004, the accused, that is here the respondent, Pandav Rai, he is allegedly entered the house of the victim in a Narangi village of Jharkhand. Then the respondent actually pushed the victim to the ground and he committed rape on her, and actually he threatened to kill her also. But she raised the alarm. She resisted to her maximum, but she could not hold him because of course, since she is a woman, she could not withstand him. So after committing the rape, she raised alarm. When the people were about to come, he left her, he poured kerose in her hair and lit her with a matchstick, due to which she was engulfed in flames, and this fellow ran away. Ultimately, her relatives came there, so immediately shifted her to the nearby Sadar Hospital, Devghad. She was shifted to Sadar Hospital, Devghad. Here the main point comes. After reaching the hospital, the in charge of the station house officer at Devghad, he went there, he went to the spot and immediately recorded the statement of the victim. Of course, he has written it in the only narrative form, and basing on that, he registered FIR in crime number 163 by 2004 under sections 307, 341, 376 and 448 IPC. So 307 is attempt to commit murder, 341 is wrongful restraint. That means he restrained her to get away from the house. That means he has locked her in the house. 376 rape, 448 that is committing house trespass, entered the house so committed the trespass without her permission. If you go into another house without the permission, it amounts to trespass. And ultimately this incident happened on 7/11 while undergoing treatment. On 14/11/2014 she croaked or she died. And please remember, here the accused was arrested, the charge sheet was filed, and actually during the examination, during the examination of witnesses, the topic of dying declaration came. The IO clearly in his cross-examination admitted that he did not call the judicial magistrate to record the dying declaration. Right? Okay. But anyway, the DD was agreed to, or the evidence part of the DD was agreed to, or is considered by the trial court who convicted the accused person. But when the matter was filed as an appeal before the High Court of Jharkhand, so they have allowed the appeal and acquitted the same. Therefore, the state went against the acquittal to the Honorable Supreme Court of India. So please here, the Supreme Court of India, basing on the documentary evidence, concerned that A, the accused person, poured kerosene and set her on fire, before which he committed the heinous rape on her. So here the point is, there is no rule that DD is admissible merely because it was recorded by a police personnel. Everybody, a doctor, anybody. Incidentally, this DD, the document or statement is supported by the certificate of the medical officer who stated that the patient was conscious and fit to give a statement. So here, only thing is, it is only an error which can be cured. Normal error is that the medical officer should have sent a memo to the judicial magistrate to come and record the statement. At least the police should have filed a memo before the court to asking the magistrate to come and record the dying declaration. Actually, the concerned medical officer should have done it. Anyway, there is a failure. But our point is whether DD recorded by a police person is admissible or not. Supreme Court said yes. So when it is recorded, so the DD, the dying declaration, the admission of the DD depends on the facts and circumstances of each particular case. Here, the dying declaration is satisfactory. So therefore, the conviction given by the trial court is restored and the acquittal given by the High Court is dismissed. So very good, an important decision regarding the dying declaration. So whenever such incidents do come to your notice, be satisfied that not only the magistrate, the police is also empowered to record the dying declaration, and there is no hard and fast rule that DD recorded by police is inadmissible. Here, as students, please remember, don't forget to cite the case of Pakala Narayan Swami versus King the Emperor or the Emperor. Whenever any dying declaration case comes to your notice, don't forget this case law. With this, I am stopping. Thank you very much.